Protective orders in Oklahoma can be a tool to help keep you safe from someone, but there are things you need to know before you file for one or if one is filed against you. Attorney Alexis Gardner with me in studio once again to talk about today protective orders in Oklahoma. Good morning.
Good morning, Dave.
So Alexis, kind of establishing the groundwork. What is a protective order in Oklahoma and what does it do? What does it not do?
So a protective order is a formal method essentially to keep someone away from you. And they are available to people who have been physically harmed, threatened with physical harm, stalked, or harassed. And usually, or prior to the law just changing, the person who stalked or harassed or physically harmed you had to be either a family member, a former family member, or someone you were previously in a romantic relationship with. But now the law has expanded to include people you aren't related to or were in a romantic relationship with but lived in the same household. So essentially it puts someone on notice that they are not to come near you, they are not to contact you, and if they violate it, there are criminal ramifications.
And that law that we've reported to you here on News on 6, the Stephen Bernius Memorial Act, it was signed by the governor, and so it is now in effect kind of expanding that definition. As we've kind of put up this graphic here to show folks where we're going, I wanted to ask this question too. So how do you file a protective order? It has to be in person?
Yes, so in the Family Safety Center in the basement of the Tulsa Police Department at 600 Civic Circle, right next door to the Tulsa County Courthouse, you can file one against a family member or former romantic partner. If it's anyone else, like that roommate situation we talked about, then that would be on the second floor of Tulsa County. And if you do it before 3 p.m. that day, a judge will review your petition and you can get an emergency protective order that day. That's just the first step, though. The person who the protective order is against has to be formally served by the sheriff, and then they have to have an opportunity to be heard where both sides can be heard. So the thing with protective orders is you can get an emergency one just with your side of events if you meet the statutory requirements. And then that's just put in place for 30 days while you wait for that person to get served so that their side can be heard. If they don't show up to that second hearing and you can prove that they were served, then you'll get a default protective order. If they do show up, then the judge will hear evidence and decide, okay, I'm dismissing this emergency protective order, I'm going to issue one indefinitely, or I'm going to issue one for 30 days or 2 years, depending.
And what's the typical length? Is there such thing as a lifetime protective order in Oklahoma?
Yes, there are, and it's up to the judge's discretion how long they want to issue the protective order for. I've had a very close case where it was kind of a lover's quarrel and no one got hurt, but there were issues on both sides, and the judge just issued one for 1 month so that essentially they could move out, go their separate ways. But it depends how severe the threats of harm are or the acts of stalking or harassment.
It's interesting when you said about the emergency protective order. We've done stories on this in the past, but I think it's important to reiterate that in an emergency protective order, one side can show up and that's good for 30 days, regardless of if that other person was with you or not, but they do have to be served.
Yes, so it's actually quite problematic because potentially you get one for 30 days, and if the police are not able to find that person and serve them with it, then it gets renewed for another 30 days. And sometimes it gets renewed for every 30 days for 6 months, and the person hasn't been served. So sometimes it is used as currency or leverage to get revenge on someone, to, embarrass them and to immune their character in the public eye. So it's not something to just file frivolously or to get the edge in a divorce or custody case. It's a serious matter, and it can affect someone's reputation.
If it is filed against you in some of the circumstances that you just mentioned, where, boy, this is like against my character, like I don't know what to do, or I totally disagree with what this says, like if it's filed against someone, you are required to show up to court eventually?
So, and once you're put on formal notice, once you're served, then yes, you're known as being on notice. You need to show up if you want to contest it. If you don't want to contest it and you say, hey, I never want to see this person again anyway, then you can just not show up and that person's going to get their default protective order. But if you do want to contest it, it's a good idea to get an attorney. people sometimes have heard that there's a protective order against them, but they haven't been formally served. You can go to oscn.net, which is the Oklahoma State Court Network,
yes.
And type in your name to see if one has been filed against you. But even if you see one has been filed against you and you still haven't been served, then you're not known as being on formal notice. So if you end up, seeing this person at the store or something, they can't call the police and say that, you violated your protective order because you weren't on formal notice.
All right, Alexis Gardner, as always, thank you so much. So much interesting information.
Always a pleasure to be here, Dave.